Good afternoon. Welcome to another edition of Legal Access. If you're tuning in today for the first time, get ready for fireworks, even though 4th of July is a couple of weeks away, because it's an HOA episode. In HOA, we usually get a lot of phone calls. So if you have any questions regarding HOAs from any side of the equation, make sure and get them in early so we can fit you in. Phone number is on your screen, 843-848-8080. HOA law, that's our topic here today on Legal Access. Here to answer the questions for you on our panel. First of all, from the Maguire Law Firm is Mike Smith. Also welcomed into Mark Napier. And Mark, which firm are you with? And in addition to HOA, what do you work with?
Well, I'm with Joy Napier, Risher and Harden, and we do a lot of HOA work. We also do residential real estate, criminal law, and personal injury law.
And also joining us on the panel today is Sam Stathos. And Sam, same question, what firm are you with and what else do you work with?
I'm with the firm of Patrick and Stathos, and we do homeowners association law, residential, commercial real estate, business transactions, and civil litigation.
So there you go. We're well equipped to answer all of your questions. Make sure and get them in. Again, the phone number is on your screen, HOA law. Don't wait to the very end because we might not be able to fit you in. Let's go ahead and start it off now. Obviously, according to the Department of Consumer Affairs in South Carolina, Horry County leads the state in the number of complaints statewide about their HOAs. When you guys get calls in your office, what's the number one complaint that you hear about HOAs? Where they come from?
Probably lack of representation by the board. Either they don't meet often enough, or they're not listening to that particular homeowner's position, something like that, or they're upset about the way their yard looks, and they're getting grief from the association, and they don't think they should be able to do that.
Special assessments. Special assessments for different problems.
That's a good
with
one too.
Common areas that need to be repaired. You get a lot of that.
I'm going to echo what Mark and Mike have said, and I think it goes to transparency. Sometimes homeowners have a feeling that they're not getting clear, understandable communication. It's easy to say, go look at your governing documents, but realistically speaking, those were probably drafted by an attorney. Yeah. And your owner that probably looks at it maybe a few times in their lifetime when they have a problem, looks at it like, I do not understand what this is, and can you help me out? And that's an issue. I will say about assessments in the condo association world, one I think the bigger issues is the cost of insurance. And then having that snowball into a special assessment and the ability to cover that cost as a homeowner, especially if you're living in it, and are you able to sustain that? Those are real issues. Secondarily to that, I'll just say one that's popped up a few times in my office is, do we have adequate reserves for this 40-year-old building, and are we keeping track of its structural integrity?
And Sam, can you explain that a little bit more about what the reserves do and what's
Sure. So, it goes into residential and condo association world. You have capital reserves that are held, and those are usually for maintenance of the building or some sort of capital improvement, but those are funds set aside by the association for some particular need. It's not to be dipped into for general operational matters. And so there's a crazy balance you're trying to handle as an HOA board or a management company, and that is, we don't want to increase the HOA dues too terribly much because that's off-putting to the owners. Right. But at the same time, we have this legal and contractual obligation to make sure we have these funds here in the case of an emergency. And you see those in the transactional world. For example, sometimes on a new development, there'll be a closing cost for your association dues, and then there's a certain sum that says this is for capital improvements or reserves, and it's being specifically allocated towards that fund. That's a real issue in the recent years when we've had older, realistically speaking, here we are at 2025. We've got condos along the beach that are at least 40 years old. And what happened down in Florida a few years ago, yeah, reared a lot of issues which were legitimate and ones that associations need to be mindful of. And I think that it's become, insurance is a problem, but that's also just as important.
And we had a couple of closures here along the beach as well, not just Florida. Tell you what, we're off and running. We got a couple of people on the line already. Let's go ahead and start in Pawleys Island. Ted is on the line. Hi, Ted. Thanks for hanging on. What's your question for the panel today?
Yes, we have a set of stairs going up to a first floor balcony, and of course are outside the unit itself. the HOA is saying we're responsible for maintaining those stairs. I would say it's the HOA's responsibility. What does the law read on this?
I understood that it
yeah.
had something to do with
Yeah,
stairs.
basically a
but-
common property, stairs that need to be repaired. The HOA says they're responsible, but they had been told in the past that the HOA was going to take care of it.
Well, I mean, and you referenced it here a little while ago, which is the first thing people say, well, you got to look at the documents. And really, you do, because the documents define what is a common element, what is a limited common element, and then, what is the owner's property. And you look at those documents to determine what this particular area is, and then you look at the documents to see, well, if it's a limited common element, who has to pay for it?
Right.
And generally, anything within the four walls of the condominium itself is the unit owner's responsibility. Outside that wall, it's a common area or a common element, as Mark was saying. And some buildings may share. You may have one particular stairwell that is unique to a building that they could call a limited common area, but the documents are what control
Right.
the matter.
Yeah.
All right, well, Ted, hopefully that answers your question, and good luck in your fight there. Let's go to Myrtle Beach now. Kim is on the line. Hi, Kim. Thanks for calling in today. What's your question for the panel?
Yes, please. When you live in a neighborhood and you back up to a retention pond 12 feet from your property, and there's a large erosion problem all along the bank, who is responsible to pay to fix that when you pay an HOA fee that includes pond maintenance?
You're going to hear this often here, and that is you've got to look at your covenants and declarations, especially in a residential single-family home neighborhood, sounds like this is. Your property lines probably include a portion, or that'll determine, number one, does the owner own? However, the covenants will also say who is to maintain and upkeep that retention pond. Generally speaking, most often that's going to fall on the association's side of the ledger, if you will, that's their responsibility. And you as an owner have given them easement rights to come in and take care of that. So in this situation, to answer the homeowner's question, I would encourage you to speak to your property management company if that exists, and they probably have set up a system to resolve that issue, or at least address it through the homeowners association.
Right. All right, Kim, hopefully that answers your question as well. We've got a lot of great calls coming in, so if you are calling, make sure you go ahead and call us. HOA law, that's our topic here today. We got time for one more quick call before we have to run to break. Linda's been hanging on patiently. Hi, Linda, thanks for calling in today. What's your question?
Hi, my question is on the number of board members. We were a 3-member board. We had in our documents the ability to go to a 5-member board, which the board did. Then when one of them resigned from the board decided not to fill that and keep it a 4-member board, which seems weird because you can't have a majority there. Is that their right to do so? Or once they took it to 5 members, do they have to maintain 5 members unless nobody wants to run and fill it?
Well, sometimes your bylaws can be amended just by the board. Again, it depends on what your documents say. And if the bylaws were, if there was actual amendment to the bylaws in which they changed it so that they could now have 5 members, then unless they went through the steps to amend them again, then they are stuck with the 5, and they have a duty then to have that 5th member.
I agree with Mark. Unfortunately, that's what you're going to have to do. Go to your bylaws, see what is permitted. But if it's for a 5-member board, you have to take action to try to fill those seats through your owners, through your membership.
All right, Linda, good question. Like I said, we've been off to a great start here already. We've got a bunch of calls we've already answered, and we've still got plenty of time to get you in as well. If you have any questions about HOA law, whether you're a board member right now or you have any problems with your board or the HOA or POA that you will work under right now, so give us a call. The phone number is on your screen, 843-848-8080. Going to take a quick little break. We'll be right back here on Legal Access, brought to you by the Maguire Law Firm. Welcome back to Legal Access, brought to you by the Maguire Law Firm. Today's topic, HOA law, and as I said at the very beginning of the show, always very popular and always very fiery. So if you have any kind of questions, don't wait to the very end because we probably won't be able to fit you in. Go ahead and call us now. The number's on your screen. And on the panel here today to answer your questions, we have Mike Smith, also Mark Napier, and Sam Stathos. And Sam, Mark, earlier today you talked about with our previous calls, Ted, Kim, and Linda. You said, well, if you need any help, just go to the covenants and they should be able to tell you what to do. What if they do that, or if they talk to somebody on the board or property management and they don't get any kind of relief that way? What's the next step after that?
Well, my recommendation is always to certainly seek legal counsel. That's one option. But perhaps before doing that, if it's an issue that is one that can be resolved through I'll use the term due process system that the association has. What that means is if you've got a grievance, something that you're upset about, oftentimes an association will have a process for you to appeal a decision or request a review. And sometimes that may or may not exist, but I always encourage folks, try to exhaust that as much as you possibly can within reason. And if you don't get the resolution or the response that you want, then definitely seek legal counsel. It's worth getting that information from an expert that is aware of that, that has expertise in that area of the law, and then can guide you through it. It's maybe not a bitter pill to swallow to get there, but it's worth it. Your investment in your home is a big one.
Right.
All right, guys, if you're still watching after the questions you had earlier, that might be your next option. Let's go back to the phones right now. In Myrtle Beach, Vicki is with us. Hi, Vicki. Thanks for listening through the break, and thanks for hanging on. What's your question today?
Can a homeowners association foreclose on a property with a $300 unpaid fine?
Most of the HOA documents that I've seen do allow for provisions of foreclosure of an unpaid lien. And they also include provisions for attorney's fees and costs associated with having to hire the lawyer to foreclose on the lien. So,
Well, the big question here is, she mentioned fines, and a lot of times the documents don't say that the fines become a lien on the property. It really does depend on that. I know that a lot of times with the associations, when we're talking to associations, you want to be able to have teeth, if you will, with your fining, and so usually you will try to have documents that say it. But I can tell you that the master in equity, if you try to foreclose based on a fine, you better have the language in the documents, otherwise they won't let you do it.
It needs to be included in the language, needs to be similar to that of the HOA dues, and
Right, that's right.
equate it to an HOA due type lien situation.
Right, it's true.
I echo one point Mark made about being able to present that to a master in equity, because there will be a pushback on is it expressly stated in your governing documents that permits you to bring this foreclosure and on this lien that you filed, and then to take that next step. Because it's a very severe action.
All right, tell you what, Vicki, I think we just answered her question, but she thought of another one, so we're going to welcome her back because you can double dip here on Legal Access. Vicki, thanks for calling back. What's your second question for us?
I'm sorry, I got disconnected. I had to call back. Where can you get a copy of the covenant or the bylaws?
You were kind of breaking up a little bit there. Did you guys hear? I couldn't hear you very well. Go ahead and repeat your question again there, Vicki.
Where can you get a copy of the covenant or the bylaws?
Where can you get a copy of the covenants and bylaws?
Recorded in the courthouse.
That's right. They're publicly recorded documents, the same with the Register of Deeds. So by way of example, if you are in Horry County, you could go to Conway, the Horry County Courthouse, go to the Register of Deeds office, and they will give you some help there. You need to have some information about the name of your association and additional information specific to your situation. But they are publicly recorded documents. The other place I would perhaps they exist is if your property, if your homeowners association is managed by a property management company, they oftentimes have websites that you can access these same documents that are in the Horry County public records.
And not to mention, you're supposed to be given access to those
That's
documents.
Exactly, absolutely.
Right. At closing, or if they're amended, then they also have a duty to to make those available
No, absolutely.
with the statute from 2019. So.
Let's go back to the phones again. If you have any HOA questions, get the calls in as quick as you can because we still got about 15 minutes, so we've got plenty of time for you. Let's go to Conway right now. Mary's on the line. Hi, Mary. Thanks for calling in. What's your question for the panel today?
Yes, can an HOA be done away with because they don't have board members, lack of the HOA fulfilling their duties?
Wow.
Well, trying to get rid of an HOA is not an easy thing to do. And I know that a lot of associations do have the problem that they can't get people to run for the board, and they can't get people to go to the meetings to elect a board, and so you're kind of stuck. But to be able to get rid of an association, usually there's some language at the tail end of the documents that reference being able to dissolve the association, but usually it requires a vote of 100% of the owners to do it.
And if it's one of those older documents that were first filed in Horry County, a lot of times you see not only 100% of the owners, but you've got that
Mortgage holder.
the mortgage holders
Right.
too have to agree to.
That,
That's a good point.
that's
Make
an
an
excellent point. And we've had that question in our office, and Mike, we've seen those documents.
Right.
Right. That you look at it and you go, it's not just the homeowners, it's also these lenders that are that have loaned on these homes.
So the answer is it's very, very difficult to try to dissolve.
What if, kind of expounding on what she had to say, if the board, gets upset about whatever's going on, they decide they all want to quit, and nobody, as you mentioned, Mark, wants to fill those shoes. So they got nobody on the board and nobody wants to run for the board. They got nobody at the helm. What happens then?
You could file a declaratory judgment action to try to dissolve it, I would guess.
Yeah, you have some kind of a town meeting trying to get people to understand why they need to have a board, and you can call a special meeting of the owners. There are, you can that is set forth in either the documents, or if it's not in the bylaws, it's statutory in the Nonprofit Corporations Act. Try to have a special meeting of the members. But again, the reason you're having this is because nobody's coming. So I guess if you call a special meeting, I don't know if that's gonna help it. You have any ideas?
Well, I'll tell you what usually will happen is some dire need will arise. We don't have proper landscaping for our common elements, or something happens. Something has happened that a majority of the owners, if you will, or even if it's to Mark's point, it could be a minority that calls for a special meeting, but then brings this to the rest of the homeowners, and at that type of an event, would you be able to perhaps explain why we need to actually be involved, et cetera? Because the last thing a homeowner association wants is to have some sort of flooding issue and a fight with the county,
Right.
and the county tells you it's your problem, and then it becomes everybody else's problem and that homeowners. Those aren't extreme examples. I think those are real, especially in our area.
I tell you what, we're going to run to a break here real quick. This will be our final break. When we get back, chance for your final calls. We'll have just under 10 minutes, so go ahead and call the number on your screen. We'll get you on the air here and get your questions answered on HOA law here today on Legal Access, brought to you by the Maguire Law Firm. Welcome back. It's Legal Access. HOA law is our topic here today, and as always, a spirited discussion whenever HOA rears its ugly head. So we appreciate all the people who have been calling in today and asking questions. And every time we have an HOA topic, there's always a call or two from Little River. And Stacy from Little River is our first contestant from Little River. So Stacy, thanks for hanging on through the break. What's your question today?
Yes, hi. My question is in regards to our HOA had a reserve study done by a professional firm, which then listed out specific projects to be completed by year. The HOA took dollars this year for a project not listed, and so was wondering what recourses we have.
Well, I think that if one of the things that you could do is, as a homeowner, request that they reconsider and follow through with what's been recommended as far as the study and what's the priority. The other part, it may not be the best thing to do, is if you're not happy with the leadership, frankly, is get involved, be part of a committee, be part of the run for the board, frankly, and to help bring attention to what's a need based on this study as opposed to what your current board did. It doesn't necessarily mean that they did anything improper based on what you've shared, but there is a duty that they have to make sure that they do what's in the best interest of the HOA. And if you deem that this wasn't something that was in the best interest of the HOA in their administration of their responsibilities, then my recommendation is to always try to get this reconsidered, bring it to the attention of the board, bring it to the attention of your homeowners, and if it's not getting resolved, or at least getting the attention you believe it is necessary, then perhaps getting involved in a process of which is democratic. Get on the board, run for office, and be a voice for those concerns that you raise.
All right, Stacy, thanks for calling in. Appreciate that. We got time at least for Dan to get in here. Dan, hi, thanks for holding on. What's your question today? Dan, you still there? We may have lost Dan. All right, well, let's go ahead and go to... Oh, we got... Okay, Dan is there. So, Dan, go ahead. What's your question for the panel?
My question is, can a board make a decision on the paint color of the buildings without any communication to homeowners?
Well, whether they can make a decision about the paint color, we'll talk about that first, I guess. Usually, associations do have, whether it's a ARB or ARC committee that is responsible for determining what people can do with their yards, what color paints they can have, that kind of thing. And a lot of times approval is required. Now, it is always a good idea to have good communication from the board, certainly, to let homeowners know these are the parameters within which you can do things, and these are the parameters that you cannot. And so I agree with you, Dan, that certainly the board should communicate a little bit better with you members to tell you what is and is not allowed before you have to go through the process of trying to submit the request.
Dan, thanks for calling in. Hopefully that answers your question. We've got just under 2 minutes. James from Little River. James, if you can ask your question quickly, we can get you in here before the end of the show. Go ahead.
Yes. How do I go about getting an HOA that is separate from my HOA to maintain a property that, abuts to my property?
So your property shares a boundary line with another HOA property?
Yes.
That's what it sounds like. Two common areas.
Two common. So I would go to your HOA and bring this to their attention so that they can, they can be aware of it. That's one avenue. Secondarily, and perhaps just at the same time, you should just make the other HOA aware of the issue that you're bringing up. It's easy for me to say, go look in the public record and you'll find out who the other HOA is. The challenge may be for you to do that, and that's why perhaps the easier path initially is to ask your HOA to make that contact, that communication, and share that contact information with you so you can do that at the same time. Any other ideas?
No, I mean, other than that, I mean, if that doesn't work, then, and it's a refrain we use often here, but then you probably should seek your own legal counsel as well, somebody who can do the title examination to be sure that you're questioning the right people, and can also give you a better idea as to what your rights are with regards to the property and what your avenues of relief are.
All right, James, hopefully that answers your question. And we had a lot of questions here today, but we always do with HOA. I love when we have HOA as the topic. You can see I wrote down a lot of questions here, only got to one, so that's great. We appreciate all the phone calls here today. Next week when we get together here on Legal Access, personal injury is going to be our topic. So if you have any personal injury questions, hold on to them until next week, and we'll get those answered. That'll be next week right here, Thursday at 12:30. It's Legal Access, brought to you by the Maguire Law Firm. For Mike Smith, Mark Napier, and Sam Stathos, I'm Dave Priest. See you next week.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on a multitude of factors. Therefore, the information provided in this program is purposefully broad and does not constitute legal advice. Please contact and retain an attorney in order to obtain case-specific legal advice.